Time is now 3:35 p.m. The House Committee on Criminal Jurisprudence will come to order. Clerk will call the roll.
Chair Moody,
Present.
Vice Chair Cook,
Present.
Representative Bohani, Representative Bowers, Representative Darby, Representative Harrison,
Here.
Representative Leach,
Here.
Representative Christina Morales, Representative Schatzline.
Quorum is present. Members, I have a few remarks I'm going to make. Then obviously I want the Vice Chairman to make some remarks. Anybody else that has a desire to say anything at the front end of our hearing. I want to thank you all for being here today. The work this committee has the opportunity to do this session isn't just important for many policy efforts. It can be the culmination of years of hard work. For me personally, I see it as a chance to finish a job I started many sessions ago. I came into the legislature interested in criminal justice issues all the way back in 2009, and it was a different world back then. Reform was an idea that wasn't for Democrats or Republicans, but largely for clueless hippies. Our government, through prosecutions, police, prisons, and let's not forget property taxes, was growing endlessly while our liberties were shrinking at the same time. Some crimes were punished too harshly, while others were glaring holes in the system. Many people meant well, but few took the time to see whether their institutions were becoming reality. Their intentions were becoming realities. The fact is that few approached this work seriously and thoughtfully. That started to change session by session as those of us who cared deeply about this topic kept pushing, and I found great partners like Jeff Leach who wanted to see a fairer, smarter, more efficient justice system. By 2017, when I last chaired this committee, we were having serious hearings and voting bills. Topics like the death penalty, drug enforcement, asset forfeiture, right-sizing penalties, and expanding appellate relief, which would have never even gotten a hearing a few sessions before, were now being voted out of the House. What a difference a few sessions makes. From the very top, Speaker Phelan made criminal justice a top priority last session, and I know that he intends to do so again this session. So that's where we are now, a place that we can make a real difference for Texas justice. I intend to capitalize on that while running an efficient, respectful committee. These can be very emotional topics, but this will be a place where the rule will be to disagree without being disagreeable. I expect we'll set the standard for professionalism and decorum here, but I also honestly expect we'll agree far more often than not. This is a bipartisan policy arena. On the note of efficiency, the practice in many committees is to hear a bill and then pend it for a later vote. For many bills, that's just what we'll do. However, for bills that we've passed out of this committee in previous sessions, I intend to vote them the same day they're heard. We're not going to delay bills there's been a solid consensus on in the past. For new members, trust me, it's better to get to the House versus Senate fight as early as you can. However, there won't be any surprises. You'll know in advance what we expect to vote on and have every bit of information you need. My senior staff will be fully available to all members, and I encourage you to reach out to our committee clerk, Rachel Wetzel, for administrative or logistical issues, and our policy director, Alex Shawala, for any questions about what a bill does in the real world. Members, this policy area matters. It's not just about what we think is wrong, it's about our values. It's about who we are. And here, where we get to set the policy, it's about who we can be. That's what we're entrusted with in this committee, and it's an awesome privilege and responsibility. And I'm looking forward to a great session in criminal jurisprudence. With that, I will finally shut up and recognize Vice Chair Cook.
Mr. Chairman, if I may, I'd like to defer to Chairman Leach initially. I know that, like you mentioned earlier in your remarks, that the two of you have done a lot of work together in this space, and I'll say a few comments afterwards. But
Representative Leach.
Sure. Thank you, Chairman Moody and Vice Chair Cook and members of the committee. It's really an honor to be here with you, serving on this important committee. I want to thank the Speaker for appointing me to this committee under your leadership, Chairman Moody, and for really recognizing such great talent and heart and commitment from the members on this committee. I look forward to a great session for criminal justice. A lot of people don't know this story, although I've said it before from the dais, how I got interested in criminal justice reform. I'll give you the Reader's Digest version. When I first took office in 2013, it's no secret to those who've been around this building for a while that at that time I was seen as adverse to our then Speaker, Joe Strauss. I'll never forget, I went in to meet with Speaker Strauss in his office that session and handed my committee preference card to him, and I put on there civil jurisprudence. I wanted to be on the Civil Jurisprudence Committee. I don't practice criminal law. I hadn't really taken any interest in criminal law since law school. And the Speaker, instead of giving me what I had asked for, appointed me to the Criminal Jurisprudence Committee. And I remember being upset and a little bit disgruntled and disappointed at the time. But looking back, it's one of the greatest unexpected blessings that I've certainly received in my political and professional life here in the legislature. The Lord knew what he was doing, went before me and put me on this committee for a reason, and I'm so grateful for it. And so now in my 6th session, this time, I'm proud to chair the Committee on Civil Jurisprudence, and I asked to be appointed to this committee as well. We have important work, members. I can think of no more important when it comes to the life and the liberty, the freedoms and the rights of the people of Texas, all 30 million Texans. I can think of no more important committee than the one that we're sitting on here. The work that we do, every single bill, every single vote that we're going to take on this dais is going to impact a real life, a Texan, whether it's a prosecutor or a police officer, a victim, even an inmate who deserves a second chance. Maybe it's someone who we believe is innocent, sitting currently on death row. We're going to have some amazingly important discussions, and I look forward to our work together. I'm expectant that under the Speaker's leadership, whom this is a big priority for, that we're going to come together in a bipartisan and very bold way to make sure that Texas is the beacon for the rest of the country when it comes to criminal justice reform. And Chairman Moody, Vice Chair Cook, I can think of no two better individuals to lead this committee than the two of you, and look forward to a great session.
Thank you, Chairman.
Thank you.
Appreciate it. Question.
Thank you, Mr. Chairman. It's my privilege and honor to serve on this committee. I look forward to taking up the issues that come before the committee. Look forward to learning under Chairman Moody, Chairman Leach. It's always been an honor to serve with, and you know what I like about this committee really is that it is a bipartisan group of individuals working. I do want to just talk just a moment about how I see criminal jurisprudence. And during the interim, I was appointed to the Criminal Justice Reform Interim Committee, and I really look at that as a specific task, but I also really want to get to the point where when we look at criminal jurisprudence, it speaks and it includes criminal justice reform, and it's one of the same. And so, I too want to commend Speaker Phelan for his vision and his insight and his heart for this space and this topic, and look forward to digging into the mechanics of what makes criminal justice reform and how we can make that where it's just simply part of criminal jurisprudence. And so I look forward to serving and learning. And if I may just take one more moment, I want to commend the two of you for the caucus, and so for the new members here, there's a criminal justice caucus that these two individuals have established, and it's a good group to get involved with. And what I really liked about it last session as a new person, it was get a buddy, from somebody from the other side. I was obviously I got a Democrat involved, and so we joined together. And so I would really encourage you to look at that. It's a good opportunity to get to know people that are working in the area, and would encourage you to do that. And with that, I'll step and pass it back to you, Mr. Chairman.
No, that was a great caucus recruiting speech. I didn't. Applications will be in your boxes. Thank you all. I want to go around, members, if you have anybody want to weigh in. Any comments? No? Okay, well, we do have a great cross-section of stakeholders to hear from today. But before I do that, I want to come back to 2009 one last time. When I started as a freshman, Pete Gallego was chair of this committee, and he did something very foolish that I still appreciate to this day, which was to put me in charge of something. He made me the chair of a subcommittee. He said this was one of the busiest committees in the House, and one where almost every member had a bill. Members come here because something bad happened in their district and they want to make it right. So they care about the bills that they bring to us. As a member, it's a chance to build relationships and develop trust by working on things that really matter to other members. And it's a chance to learn both how to lead and how to collaborate, which makes our body stronger. The bonus to all that is that subcommittees allow our work to get done more efficiently, which is quite a rarity in government. So in the spirit of extending the same opportunity Chair Gallego gave me all those years ago, at this time, the chair names the following members to the Subcommittee on Criminal Procedure. Representative Bojani, Chair. Representative Bowers, Representative Cook. At this time, the chair names the following members to the Subcommittee on Asset Forfeiture. Representative Harrison, Chair. Representative Morales, Representative Schatzline. With that, Chair calls Nikki Presley. And Nikki, I know you know, but I'll say this for everybody who's going to be testifying today. Don't have anything before us other than commentary on our items in our general jurisdiction. So every witness will be testifying on the item rather than for and against, because we don't have anything in front of us. But with that being said, if you could state your name and whom you represent for the record.
My name is Nikki Presley. I represent the Texas Public Policy Foundation and Right on Crime. I didn't know I was going first, so now I'm a little nervous, but I thought Justin Keener was joking when he said that. But like I just said, my name is Nikki Presley. Thank you so much for having me here today. I'm really looking forward to this committee and really excited to work with all of you. So I wanted to touch on 3 different things today: civil asset forfeiture, bail reform, and then prosecutorial accountability. But if there's any other questions outside of that scope, please let me know. So first, civil asset forfeiture. Currently, law enforcement is able to seize someone's assets without formally charging a person with a crime in connection with those assets. And there are a few approaches to fixing that issue that we've seen in the past introduced. So one is fixing the innocent owner defense to shift the burden of proof onto the state to prove that the owner was unaware of the criminal activity, whereas now you have to prove that you were unaware of the criminal activity. Raising the burden of proof for the state to seize and forfeit someone's property. Right now it's preponderance of the evidence. It could be raised to clear and convincing. Reimbursing attorney fees if the owner is found to be innocent, and the most extreme would probably be shifting to a full criminal asset forfeiture system, meaning there would need to be a conviction in order to forfeit those assets to the state. There's probably a happy medium somewhere in there where you could forfeit once a charge is filed. But those are what we've seen in the past. And then additionally, there is a transparency issue with civil asset forfeiture proceedings. You have to submit a public information request to see what's being seized, what it's being used for, how much is actually being forfeited, if it's involved with an actual conviction. And I requested an office to request that information from the Attorney General's office, and it took them months, and it was not easy for them to do. So if anyone would like that data, I have it by agency and by county DA office.
Actually, if you could provide it to the committee, and then we'll provide it to the members.
Of course, and I'm not like the gatekeeper of that. It's Representative Canales, Chairman Canales requested it for me. So that's that on that. And then next is bail reform. As y'all probably saw, the governor established this an emergency item on Thursday night. And what Right on Crime has always advocated for is for bail to be based on someone's risk, not someone's ability to pay. And that does include denying bail whenever there's a high risk, a clear and convincing risk that they're a danger to public safety or a flight risk. Currently, a judge can only deny bail for a capital offense or if there has been a certain criteria of repeat felonies. So there could be a constitutional amendment passed that would allow judges that ability to deny bail in those serious cases. And then finally, I wanted to touch on prosecutorial accountability, sometimes being called rogue prosecutor issue, but I would like to call it prosecutorial accountability. This was also deemed an emergency item by Governor Abbott the other day. And I just wanted to say that there are 2 major things that I think we should keep in mind whenever we are approaching this topic. And the first one is we need to be very the legislature should be very delicate in defining the difference between prosecutorial discretion and a prosecutor using that discretion, whether it be resource issues or needing to prioritize higher risk crimes, higher felonies rather than misdemeanors, versus when a prosecutor is actually acting in rebellion and failing to fulfill their state duties as an elected official. And the second thing is the question of if the Attorney General has the power to investigate and pursue removal of district attorneys. In conversations that I've been having, there's been mixed responses on that. Some people say he does have the power and we wouldn't need a constitutional amendment. Some people say he doesn't have the power and we need a constitutional amendment. And I don't necessarily have the answer for you today, but I think that that is definitely something to discuss and explore and find an answer to. And that is all I had today, but please let me know if you have any questions. I'm happy to get with y'all's offices too, and I will get you that data.
Thank you very much, Nikki. I appreciate it. And obviously, members, you're going to see people here that you're going to see multiple times throughout session, and are going to be a resource for you if you want them to be. But open the floor for if you all have any questions for Nikki right now. My guess is you'll be asking her a lot of questions over the next several weeks.
Yeah,
So,
thank you.
Nikki, thank you so much.
Thank you.
Chair recognizes that Chairman Darby has joined us. I'm going to take an El Paso liberty here, and I know that we have Judge Maria Salas Mendoza from 120th District Court in El Paso. I know it is challenging to travel back and forth from El Paso, as I do it every week, and so, Judge, I'd like to recognize you for your testimony. You state your name, whom you represent, and then you are testifying on the matter.
Thank you, Chair Moody. I am representing myself. My name is Maria Salas Mendoza. I'm the judge of the 120th District Court. I've been the judge of that court for the last 16 years. This is my 17th year on the bench. I was 12. I know you gave me that one. I was 12. Chair Moody, thank you for inviting me. I was glad not to be first, but I'm not sure taking the El Paso privilege really helps me out here. It's been a long time since I've been on this side and having to address folks. So I want to let you know that I wanted to address bail and bail reform. I don't have a whole lot of comments. I know y'all think that lawyers always say that, but I really am going to be brief. But I didn't want to give up the opportunity to share with you my experience and my feelings about bail. I have always said that setting bond and setting bail is one of the most daunting, one of the most challenging, and frankly, one of the most scary things we do on the bench. In the old days, in 2007, we really relied on criminal history. That's what was given to us. The prosecutors often gave us the criminal history of the person. If we were lucky, they'd had a probation case and we might have some information about how they did on probation, whether they report it. Sometimes we'd have information about compliance on bond. But frequently, the only thing we really relied on was criminal history. And then, like a crystal ball, we were supposed to know if that person was going to come back to court, whether they had a risk, presented a risk to the community or not. And that's basically it. And that's how we made our decisions. As you know, there's been a whole amendment to Chapter 17 of the Code of Criminal Procedure, adding the public safety report, a whole entire system that came into play this last year or so. It took effect in April of 2022, but it rolled out over the last year, lots of training, an entire software system where we had to have staff trained, judges trained, a lot of expense, a lot of ideas about improving the information that judges had about setting bond. And I have to tell you that what I get is criminal history. That's what I get. After all of this training, lots of resource hours, a lot of consensus building with clerks and other staff members about who was going to pull the public safety report and make it available to the judges. And what I have is criminal history. And in addition to not having more information that helps me make a bond decision, I have to, at the end of the day, go back and certify that I've looked at the bond history. I have to enter those bond conditions. I have to fill out another form that says what I did. at that bond hearing. I don't have time to do it at the time of the hearing because I've got other people behind, and typically it's a remote hearing with defendants at the jail. So I have to come back at the end of the day, and I'm ordered to do it within 72 hours to provide you the same information that's available in every single bond order that I already signed. Because all bond orders are available publicly, you can get them, and you can look at what I'm doing in every single case. But now I have to go back and fill that form out. I want to fill that form out. I wanted to say also that in addition to really not giving me better information, the scary part is still there, right? Because I'm still having to set bond, the character of the bond, and I still have a duty to set a reasonable bond that is the least restrictive bond that still ensures the safety of the community. And so in that sense, it's good because I'm not asking y'all to tell me that. I do think that you need to give us the discretion to do that, but really we're not getting any more information. What we did get with the Damon Allen Act is a lot of restrictions, and you already mentioned them, that in certain, actually, you just mentioned in cases where we cannot set bail. But in addition, if you have someone with an assaultive history, and that's one that comes up most often, if someone has an assault in their criminal history, it doesn't matter if it was 2 decades ago. It doesn't matter if it was a scuffle between brothers. If there's an assaultive history, then there's a prohibition on PR bonds. And I will tell you that there's so many situations that come before us that there are too many different exceptions that I could tell you. I would just tell you the most recent one, an individual who is on probation for an assault, and it does involve a partner. He's compliant. He's compliant on probation. He's doing everything he needs to do, and he did pick up a new drug offense. Well, he's not entitled to PR bond, even though he's been sitting in the jail. And the state is asking me to PR the bond because their case can't be resolved without a lab report, and they don't know when they're going to get it. And so either I reduce that bond so that he makes that bond, but I can't PR it, even though I have no basis to believe there's risk to the community. So the last thing I wanted to mention is that the El Paso situation was completely ignored. I want to say it was about 2014 that we ourselves took it upon to improve our pretrial services. And we developed a pretrial services report. Judges were involved in the development of that report. Community supervision officers were involved. All kinds of district attorneys, defense attorneys, everyone who had a stake in the system was called on to decide what would go into this pretrial services report. And we started to use a pretrial services report, which gives us criminal history, but it also tells us some additional information that the subject matter experts informed us were relevant for us to consider in deciding risk. And that is resident stability, employment, the age of the first offense, whether they were on a bond at the time, whether they had already been on probation, a whole sort of information that the subject matter experts informed us would be appropriate for us to consider in evaluating risk. That pretrial services report has now been validated for El Paso County at least twice, and I want to say 3 times. The result of the validation that's been done by experts at UTEP, who I think there's now some folks at the county who are doing it, validates the results. So it tells us a percentage. There's a high risk that this individual, based on all of these factors, is likely to reoffend, is likely to show up for court, is likely to commit a serious offense. And it gives us a percentage. The judge still has to make a decision, but it helps us. It informs our decisions. And if that was the goal of bail reform, then that's the kind of tool we needed. But I reiterate that that's what we did in El Paso, and it's a tool that is validated for El Paso. You couldn't drop that tool in Austin and have the same results because it's based on our community. It's based on the results in our community. And so in closing, I will say that for the important work that you do, and it is so very important, and that you mentioned that you will affect a person. You will affect a victim. You will affect a person who's accused. You will affect the safety of our community at large. that is not the same in the 254 counties of the state. It is simply not the same. And the problems that exist in some counties simply do not exist in other counties. And to have a whole fell swoop change in the law that doesn't address the problems, and if they've been addressed by a particular county, for me, and since the impact on me is that I now have more work. Not better bond decisions, not improved in any way, unless I'm using my tool, and really just adding to already a burden system. And so I would ask that you consider that, to take into account what counties have done, and also not to punish all of us for what I know. There are some judges that I've been hearing that there's rogue judges, and people are concerned about these rogue judges. I think that's appropriate, and I think that that certainly you have the ability to do that. But so many of us are trying to make the right decisions to not harm people as we make these decisions, and certainly to keep our community safe. And for us not to be, to lose our immunity in that decision making that must involve discretion. It would really be, really tie our hands more than it is already tied. And I would ask that you consider that. That's all I had.
Thank you, Judge. Members, any questions? No, she's going to say no. All right, I'm going to listen. I'm going to listen to her.
I'm glad
No, I appreciate it. Thank you. I do want to say that issues related to bail reform have been in this committee for years. In its most recent iteration, it probably started in 2017, where we were tasked with looking at that in depth. Obviously, the governor believes that's something that we still need to work on, and so my guess is we will be working on it this session. So the complexities that the judge fleshed out are things that we need to consider as we get back into that subject matter. It's highly complex and involves some federal litigation and lots of systems around the state, and so we'll need to really consider all of those individualized decision-making processes. So let's see. Chair will call Clinton Young. Clinton, thank you for being here. Just, and state your name, whom you represent, and that you're testifying on the matter today.
Okay, first I want to thank Chairman Moody and the committee members for this opportunity. My name is Clinton Young. I represent myself. I guess the gist of what I'm testifying about is the problems that plague the death penalty and our appeal system in Texas. The story is kind of a unique one. When I was 18, I was arrested for capital murder. When I was 19, I was sentenced to death. In October 26, 2017, I received an execution date. The fact that I'm standing here before y'all clearly shows that things weren't routine as usual in the state of Texas. In 2021, my conviction was overturned and I was eventually released, and here I am today.
Clinton, let me do this. I know that, have you testified in the committee before? Somebody, if you can come a little bit closer. I think your story is very important for people to hear, and I want to make sure they're able to do that. So it's not just for the folks that are in the room, but it's being recorded, and so if you speak clearly into the microphone, I want to make sure people hear your story.
A lot of problems that plague my case isn't unique to my case. I was just blessed to get good attorneys towards the end that fought for me and had the same funding as the state did, basically. Matter of fact, I was the first person in Texas to have the capital habeas unit on this case out of Los Angeles, California. And eventually the Fifth Circuit instituted those, and then the Texas legislature introduced the Texas capital habeas unit office, excuse me. On my appeals, my state writ of habeas corpus, which everybody knows as a lawyer knows is one of the most important appeals, especially for a death penalty offense. Well, unfortunately, my investigator and mitigation specialist that was appointed to me had a drug habit, and the money that was given to her to investigate my case was used to buy crack cocaine. And so she falsified a bunch of affidavits, and basically I had no state writ. It was built on a crackhead's delusions. Instead of the CCA giving me another opportunity to file a writ of habeas corpus, the prosecutors opposed anything like that. He refused to prosecute Lisa Milstein, the person that was appointed to me. And so when my lawyers filed a new writ, because again, my original writ was nothing but the delusional statements, forged statements of a crackhead. The Court of Criminal Appeals decided that it was abuse of writ. And so I went into federal court with no writ of habeas corpus, which then when I entered federal court, because the way the laws are, I was then procedurally barred from filing anything that would have proved my innocence or prosecutor misconduct or ineffective assistance of counsel. And add insult to injury, the money that investigator used to buy crack, the court put on me to garnish my commissary account. And so I ended up having to pay for the harm that was done to my case. Years later, after attorneys digging and finding new evidence, after I eventually went through the appeal process, I was given my execution date. We filed a last-minute writ of habeas corpus, and based on the development of forensic testing, the legislator had made some changes to the law while I was down there involving 11071 and 11073. Did kind of open the door a little bit, but it still left a lot of discretion for the CCA. Basically, additional forensic testing was allowed to be done, and it pointed to my co-defendant, all of it. And while I was sitting on death row waiting to be executed, the prosecutors bench warranted my co-defendant back to the county jail. He partially confessed. I didn't find out this confession until I got a stay of execution. The confession would have guaranteed me a stay, but they withheld it. And so, as I waited on my hearing after I received a stay of execution, it was discovered in Midland County that the prosecutor that had took a primary role in my case was getting paid by the judge. And so he would literally do the work as a prosecutor, get paid as a prosecutor, go in there, write up everything for the judge to say, and then the judge would pay him. This incident kind of made headlines around the world, front page USA Today, and it proved to be too much. And so eventually, after they sorted out new prosecutors and judges getting on the case, the Court of Criminal Appeals overturned my conviction. And here I am today. I would like to say that, you know, while my case has a lot of the more extreme elements, you know, the problems that plagued it, the problems that plaguing the appeal system in the state of Texas aren't rare. I mean, there's people who, you take the Rodney Reed case, which is well known, I'm sure some of y'all know about it. Then there's the Robert Pruitt case, who was executed. You had the Todd Willingham case, on and on and on. There's a lot of cases that don't get the publicity like I got, or Rodney Reed, and a few others have, be it because of their mental illness, their intellectual disability, they can't adequately convey the problems with their case, or just they get stuck with lawyers that don't care about them like mine ended up caring about me. The law has been created in such a way, which I understand, I get it, that nobody wants guilty people to game the system and get released. I understand that, okay? I'm not against police, I'm not against prosecutors, I'm not against the penitentiary. But the problem comes in is how the laws have gone so extreme, they trap people. I mean, it's almost, the bar is set so high. Like I said, I had no state writ of habeas corpus. It was, nobody disputed what happened in my case with my investigator, and that my whole writ was destroyed, and there was other viable claims that could have been raised. And when I tried to raise them, they said it was abuse of writ. And so I sat on death row for 18 and a half years. And it wasn't because my lawyers possessed some magical ability to like delay everything, because we're bound by strict guidelines. So this idea that people languish on death row for 25, 30 years, that it's somehow the defendant's fault. It's not. We don't have the power to do anything. And so I guess to wrap it up is say that there has to be some way to find a common medium to where people aren't being trapped by the system, you know, and facing wrongful execution, or not only that, wrongful imprisonment. Death penalty cases generally get the most publicity because it's the government attempting to take a citizen's life. But there's countless people still in the penitentiary who have life sentences, 60 years, 80 years, 99 years. And the fortunate thing about death row is we're guaranteed an attorney. If you have a life sentence, you're not guaranteed an attorney. And so you're stuck to file things pro se. Well, fortunately, I've been in prison most of my life, and I'm here to tell you that it's not full of scholars. I mean, it's not full of, I mean, it's just the reality. I'd be like, dang, boy, I thought that was a good idea. But it's just, and so you have bare minimum in a law library, and you're asked to turn around and file writs or direct appeals and everything on your own. And if you don't do it right, you're procedurally barred. And then based on the AEDPA, which is, of course, on the federal level, if you're procedurally barred in state court, it's a wrap when you go into federal court. And there's been countless federal judges who said, hey, I'd like to be able to do this, but I can't. There's been district court judges say, I'd like to be able to do this, but I can't. And so, I guess, a checks and balance, on, I guess, on the Court of Criminal Appeals, because they interpret everything y'all say to the most extreme level, you know, and it's to the detriment of people who have lost their liberty and very well might lose their life. Thank you.
Thank you, Mr. Young. I appreciate that. Members, real quick before, did you have any questions? Chairman Leach.
Thank you, Mr. Young. Just very briefly, and I hope you'll, when we have some death penalty bills in front of this committee, which I'm sure we will, I hope you'll come back and let us ask you more questions about the details of your case and your time in on death row. You were in for 18 and a half years, is that correct?
Yes, sir.
23 and a half hours a day in solitary confinement?
Yes, sir.
And you were within 8 days of your execution date?
Yes, sir.
And, okay. We hear about cases like yours and Melissa Lucio as recently as this past summer, and Jeff Wood, and there are others. You mentioned Rodney Reed and Willingham. And members, I just want to encourage you to, just from my experience as someone who is a death penalty supporter in the most heinous cases, it is good and right and necessary for us to question the system and for us to ask hard questions and to understand where the holes are that need filling and where the weaknesses are that need strengthening. I am severely and increasingly concerned about the way we, no pun intended, execute the death penalty in Texas. And we're gonna ask the tough questions in this committee under your leadership, Mr. Chairman. When we do so, we don't weaken the system, we strengthen the system. And so I want to thank you for being here today and look forward to getting to know you and learning more about your case in the days ahead.
Thank you. Members, do we have any other questions for Mr. Yes, Representative Bowers?
Thank you, Chair Moody, and thank you, Chairman Leach, if I might say, and Mr. Young. It's more of a statement as well. Serving on the Speaker's Select Committee in the summer on criminal justice reform with others on this committee, it was an honor to serve under Chairman Leach at the time. As he said, he is a supporter of the death penalty, but you could see the bipartisan work that we did, and I am thankful for your stay. We worked so hard to make sure that Melissa Lucio received her stay of execution, and that the fact that now you are using your life in testimony of, you know, no matter what you did, you are now here on behalf of others. So thank you for making such a good example of your life, and thank you, Chairman Moody, for allowing me a moment to say.
Absolutely, thank you. Members, do we have any other questions? Mr. Young, let me ask you, I know that we've got your contact information. If you don't mind, I assume that we're going to hear from you again. I want to share your information with the members of the committee, if that's okay, if they have questions to follow up on, so that they can get a little bit deeper and understand what happened in your case. It won't be the only one that they hear about, but it's something I think would be important for them to dig into.
Yes, sir.
Thank you very much.
Yes, sir.
Chair calls Elizabeth Henneke.
Hi, everybody. My name is Elizabeth Henneke, and I am an attorney with the Lone Star Justice Alliance. And I prepared remarks, but in light of your statement, if you'll just give me a moment, I just want to talk about how grateful I am to be here today and the journey that I've had in Texas related to reform. So some of you know this story, that I grew up on a prison here in Texas, in Huntsville, Texas. My father was a prison guard out at the Gore Re unit. My grandfather was assistant warden of death row and oversaw most executions through the 80s and the early 90s. And my grandmother's a Walker County Sheriff's deputy. So I grew up in the days that we talked about crime and we talked about super predators. And then I spent during the summers in the Walker County jail with my grandmother, who ran the jail, but in the back with the inmates who cooked in the kitchen. And I learned how poverty and trauma and lack of opportunity and drug addiction were flooding our jails. And instead of responding with compassion and redirection and rehabilitation, we were responding with punishment. And that set me on a journey that has spanned several decades, looking into the criminal justice system. I've been a law professor at University of Southern California School of Law, where I taught criminal law and I supervised a clinic. And now I run this nonprofit, which seeks to bring evidence-based practices here to the state of Texas. But our stories interact and intersect, Chairman Moody, because I came back to Texas after a roundabout way, because in 2009, I finished clerking for the Fifth Circuit Court of Appeals. And I watched as we executed 12 men and women over the course of the year that I clerked. And my job as a clerk was to take the phone calls for the last minute stays and to present them to my judge. And after that experience clerking out of San Antonio and listening and denying 12 men and women the opportunity to receive stays of appeal and waiting, because clerks are asked to wait until the execution is complete, I left our state, the state that I'd grown up in, that I called my home. And I went to DC, I went into private practice, and ultimately into academia. And then an amazing article came out in 2014, and it was about the work that you all were doing. It was the work that the House was doing to transform our criminal justice system. There was an article written by the Texas Association of Business and Bill Hammond, many of whom you may know, who said that their work of bipartisanship was launching in the state of Texas, and that we were going to change the way we responded to poverty and trauma, and we were going to launch our rehabilitative efforts. And my husband, who is, by the way, of course, keeping with the family business, a U.S. attorney and a AUSA here, a federal prosecutor, and I came home. And my journey at home has been so defined by the work that you've done. We've partnered together on the Second Look Act. We've sought to reform juvenile justice. We've been in Dallas, where we've launched innovative programs. The work you've done has inspired me every day, and I'm so grateful to you, because it really has fulfilled the belief that I have in Texas, that we can lead with compassion, with firmness, and accountability. And so I look forward so much to working with each of you, because this is my life. This is the family business. We're 7 generations of Texans working in criminal justice reform. So if you have questions, I will always be available to you. So now I'll turn to my prepared remarks. Is that okay?
Of course.
All right. This is the problem with putting a trial lawyer up. We do talk too much, right? So real quickly, I want to talk to you about young adults. And I'm going to ask you to embark upon the next wave of criminal justice reform as we really try to change the way we work with our young adults. So I just want to start with one quick question and a show of hands. How many of you would invest $5 billion in a company that fails 75% of the time? You're not taking me up on that investment? Well, unfortunately, as taxpayers, you do that every year, because that's our recidivism rate for young adults in the state of Texas. 75% of them that enter into the criminal justice system are going to reoffend within 3 years. So you make that investment. And I'm going to give you an opportunity to shift so that your return on investment will benefit your communities and stop public safety. So I want to talk about those efforts. I've given you 2 documents which reflect the research. This is, again, the former law professor in me. 2 documents that reflect the research on young adults. And this research has been presented nationally. I sit on the National Conference of State Legislatures and the National League of Cities Young Adult work. And what it does is it identifies the ways in which emerging adults between 17 to 24-year-olds are different than older aged individuals, right? And the intervention strategies for young adults also have to be different. There's a reason we're failing 75% of the time. It's because we're misapplying the interventions for this group. Because what we know about emerging adults, any of y'all have kids? Any of you have teenagers? Okay, so what you know is what I'm going to tell you today. This is my favorite quote. They have an accelerator long before they know how to brake. They don't know how to steer, but they know how to run. And you all know that because you've been teenagers. You've made bad decisions because you act impulsively, you follow your peers, and therefore you make poor decisions. And then what we do is we penalize those poor decisions, and we don't provide them an opportunity to rehabilitate. So what we did was we asked young adults to tell us about their experience. So we researched evidence-based practices, and then we talked to youth. And what we found is youth who said the justice system must focus more on our needs. So over the course of time, you're going to be presented with lots of options that focus on needs. And what we want you to do is to look at core components. What is the mental health? My one ask for you is we have funding this session, and we must invest in mental health. Those of us who work with young adults, which are the primary population that's involved in school shootings. Again, I'm going to say that. Young adults are the primary populations that's involved in school shootings. That's my expertise. I've represented those who've been accused of school shootings here in the state of Texas. And what I can tell you is that there is a lack of mental health supports that is making our schools less safe. And I've got a 6 and 8-year-old. And I'm going to beg that you actually, this legislative session, invest in mental health. And I provided you statistics that show you exactly what that could mean to your populations. We also need to invest in substance and mental health, substance abuse, and make sure that we address misuse programs. And then we need to address the underlying trauma, because what we know is that 52% of people, of young adults in the system, come from families of incarcerated individuals. These cyclical history families that are deepening in our justice system are impacting other parts of our population. And we know that because justice-involved respondents are 4 times more likely than other young adults to have a CPS case filed against them because of abusive neglect of their own children. Okay, so let me make clear. Young adults in the justice system are 4 times more likely to have abuse and neglect of their own children. These cycles perpetuate. So if you want to fix the CPS system, you're going to have to work with your young adults who are justice involved. And we can do that by expanding opportunities in employment and housing. So what we've tried to do is provide for you some alternatives. In Dallas, we run the transformative justice model in partnership with local district attorneys. We also do it in Williamson County, where we redirect young adults out of the criminal justice system and into wraparound redirect services. Our recidivism rates, here's your return on investment, are less than 15%. And we're doing it at a fraction of cost of what we could do in prisons. We've recently expanded that model to an employment partnership with the Texas Department of Transportation and Workforce Solutions Greater Dallas, because you need your roads built, because the Texas economy is built on the roads that transport our commerce. But we certainly can't succeed if no one's there to build that. Your young adults are prime for that. That work program has brought over 100 young adults into the workforce rather than into your prisons. We have a 0% recidivism rate 18 months in, and your roads in Dallas are being built. We look for expansion of other programs like this, and there are other nonprofits providing similar resources. So on the back, you'll see some recommendations of policies that do work, that the evidence is clear it works. So what we say is that support your specialty courts, but they can't do it alone. We must start to build community-based resources. Work and employment works. We need to create opportunities for people to get back to work in lieu of incarceration, in lieu of prison, so that our Texas economy continues to thrive, so our families continue to thrive, and so that we can look back on the last decade of leadership under Chairman Moody, under Chairman Leach, and we can say that we brought Texas back into the aspirational belief in where we could be as communities, rather than a system that penalized and incarcerates and produced a dadgum poor return on investment. Thank you all.
Thank you, Elizabeth. Members, any questions?
Thanks, y'all.
All right, thank you very much. Chair will call Jeff Burkhart.
Good afternoon, Mr. Chairman and members. My name is Jeff Burkhardt. I'm the Executive Director of the Texas Indigent Defense Commission. TIDC safeguards liberty by ensuring that Texas and its 254 counties deliver the right to counsel guaranteed by the United States and constitutions. If you've watched TV in the past 40 years, you probably heard you have the right to remain silent. Anything can be, you say may be used against you. You have the right to an attorney. If you cannot afford one, one may be appointed to you. That's where we come in, the appointed counsel piece. That's guaranteed under the Sixth Amendment to the United States Constitution and Article 1, Section 10 of the Texas Constitution. We do three things specifically. TIDC funds public defense across the state. We oversee public defense across the state. And in fact, I think we have one of the best data websites when it comes to public defense in America. And we also work to improve public defense across the state of Texas. We were created 20 years ago when Governor Perry was governor. We have a 13-member board that includes the Chief Justice of the Texas Supreme Court. It includes Presiding Judge Keller from the Court of Criminal Appeals. It also includes 2 senators and 2 representatives. Right now, that's Representative Reggie Smith and the chair of the Criminal Jurisprudence Committee.
Oh, I got to go to those again?
Yeah. We have you back. We're excited. Yeah. I'm not going to tell you too much about the importance of public defense because I think you heard from Mr. Young about why it's so important. The presence or absence of an attorney, the presence or absence of quality representation can mean the difference between liberty and lack of liberty, incarceration. It can actually mean the difference between life and death in many cases. I'm going to give you just a little bit of background on what we look like in Texas, what we look like historically, and what we look like compared to other states. While most states fund and provide public defense at the state level, Texas, we've always done it at the county level. That's one of the reasons we were created 20 years ago, was to make sure that the state had a little bit more skin in the game when it comes to funding and oversight. Because most of public defense is really provided, funded, but also really managed at the county level, we have tremendous variety when it comes to the provision of counsel. Whether or not you get an attorney, what type of attorney you get, really sometimes it really depends on what side of the county line you're on. Funding in Texas for public defense today is 83% funded by the counties and about 17% funded by the state through the Texas Indigent Defense Commission. So the counties shoulder most of the burden. And when you look at Texas compared to other states across America, the national per capita spending for public defense is about $17 per capita. And that's a real rough and ready measure. But basically what it is you take the population of any area. It could be Texas, it could be Delaware, it could be Harris County, it could be Travis County. Take the population, you take how much they spend on public defense, you divide one by the other. So the national average is $17 per capita. Texas, our average is $10 per capita, so just 60% of the national average. That's a little bit troubling, but really the part I think at TIDC that we're most worried about really is some counties are only spending $1 per capita, 6% of the national average. What that translates to in real terms is defendants who don't have counsel by their side, people with a constitutional right to a lawyer without a lawyer by their side. What it translates to is people with a constitutional right to quality representation, effective representation, who are essentially getting meet and pleads, where an attorney meets with the client, they don't have enough time, they don't have enough funding to really prepare that case. The problem with access to counsel is made worse in rural areas because we have fewer and fewer attorneys in those areas. In the past 7 years, we have lost over 500 rural defense attorneys doing indigent defense in Texas, over 500. That's 1/4 of all rural defense attorneys doing indigent defense. Some of them are retiring, some are dying off, some are saying we're not getting paid enough for this work and they're taking retained work or they're turning to civil work. That problem is made worse by the fact that new attorneys are not moving to rural areas. Depending on what source you rely on, the average law school debt now is between $160,000 and $200,000. When those law students graduate, they're not going to hang a shingle in rural Texas these days. It's not happening. So on a weekly basis right now, we get calls from judges, well-meaning judges. I mean, we don't, I think sometimes people assume that there are judges out there depriving people of counsel, twisting their evil mustache, trying to deprive people of a constitutional right. That's just not the case. I mean, that's absolutely the exception to the rule. What we see are really good people doing the best with a very difficult situation. We get calls from judges saying, look, I understand this person in front of me has the right to an attorney. But Mr. Burkhardt, what do you want me to do? We don't have the tax base for this. We don't have, even if I did, I don't have enough attorneys in my backyard to provide counsel. And so they do what they can do best, what they can, I think any of us would do in this situation, which is you prioritize, you kind of triage, and you make sure that those most important cases are getting counsel, your homicides, sex assault, those sorts of cases. And so as a result, we see a lot of folks in misdemeanor cases who aren't getting counsel. Today in Texas, if you are a rural misdemeanor defendant, you are 4 times more likely to go without counsel. So if you're a rural misdemeanor defendant with a constitutional right to a lawyer by your side, you're 4 times more likely to go without counsel than your urban counterpart. As a result of that, right now, as we sit here, about half of all rural misdemeanor defendants have no lawyer by their side in Texas. Over half of rural misdemeanor defendants. And again, that's not by design, that's just the way things have kind of shaken out, and we have counties that are in a tough spot. The last things I'll mention to you, I'll try to end on a little bit of a positive note because I know I'm talking about gloom, doom, and destruction. Things are pretty bad, and we've got a lot of work to do. This year is the 60th anniversary of Gideon versus Wainwright. Gideon versus Wainwright, the 1963 decision that created really the right to counsel as we know it under the Sixth Amendment today. So we will be having some celebrations. Unfortunately, Gideon Day is March 18th. That falls on a Saturday. So on March 17th, we're doing a Gideon Day event at the auditorium here in the Capitol. More details to follow on that. Some people call that St. Patrick's Day. We call it Gideon Day Observed. So we can hope you can join us for that. And the last thing I'll leave you with is this, and I think this is a theme that you're hearing today, that I think everyone recognizes that there may be times where you have to deprive somebody of the right to liberty. That there may be times where we have to take a person away from their community, away from their families, away from their jobs. But we better get it right. It better not be an accident because you don't have an attorney by your side. It better not be an accident because you have poorly funded counsel or an attorney with too many cases. And that's why we're here as a state entity. We really want to make sure that counsel is providing quality representation throughout the state of Texas. So thank you all for your time. I'm happy to take any questions you might have.
Jeff, thank you so much. Do we have any questions?
Just a quick point of clarification. For those misdemeanor cases where you say they do not have counsel by their side, are they representing themselves then in those instances, or what?
Yeah, that's right. Generally, they're representing themselves. And again, this is just to be clear about it. It is generally misdemeanor cases, though it is a constitutional right to an attorney under Argersinger versus Hamlin that you have a lawyer there. Generally, it's misdemeanor cases, and what we see are, again, well-meaning judges, but oftentimes doing the best with what they have. And they'll say, Mr. Burkhart, if I'm a defendant, you have the right to an attorney. We'll get you an attorney. It may take some time, but if you go and talk to this prosecutor, maybe we can get you out of here a little bit more quickly.
Thank you. I thought that was probably the case. Just wanted to clarify. Thank you,
Yeah.
Jim.
Any questions? Yes, Rep. Rajani.
Wanted to ask, if you have any solutions to the problem about rural, indigent, and not lack of defense.
Yeah, I think our biggest solution has been building rural regional public defender offices. So basically what we've done at TIDC is go to rural counties, and we don't have the authority or the desire to come in and dictate that, hey, you're going to build a public defender. But when the counties come to us and they have 3 counties or more, and we're looking for counties with a population of 100,000 or less, and they come together and they say, state, we really want to build a public defender. We go in and we fund 2/3 of that, and the counties will pay for 1/3. And in fact, that's our biggest request in terms of I know this is not House Appropriations, that's our biggest request in House Appropriations is really getting more funding to build those rural regionals. Why do those work? Those work because when you build a public defender office, those same young attorneys who aren't going to hang a shingle, they will get a salary, they get benefits, they qualify for federal loan forgiveness just like the prosecutors do. They get coaching, they get mentoring, supervision. So it works for the same reason a prosecutor's office works. You get all those sorts of benefits, while if you hung a shingle and you started your own law firm, you're not getting a salary, benefits, loan forgiveness, any supervision. I know we have several lawyers on the panel. You certainly don't graduate law school knowing how to practice law. So it kind of builds that in. So that's been our biggest solution. And we've got, I think, statewide, we're now up to roughly 70 counties with a public defender. About 40 of those are rural.
Okay, so the solution is there, that program is there, you're just requesting more funding.
That's right. That's a big part of our LAR. Right now, the demand for those offices is about twice our ability to fund them. So that's our big hope.
Okay, thank you.
Thank you, sir. Do we have any other questions? No? Thank you, Jeff.
Thank you all. Appreciate it.
Chair calls Stacy Sule.
Good afternoon. I'm Stacy Soul. I'm the state prosecuting attorney, and I can speak firsthand experience that Jeff's Gideon Day celebrations are always a lot of fun, and he has some pretty challenging trivia questions when he asks them. So I would urge you to definitely attend. Thank you for having me here today. As I said, I'm the state prosecuting attorney, and I'm the head of the Office of State Prosecuting Attorney. We are a very small office in the judicial branch, and we comprise of 3 attorneys, myself and my 2 assistants, and 1 administrative assistant. And our jurisdiction is before the Texas Court of Criminal Appeals. We have primary jurisdiction there and jurisdiction in all 14 courts of appeals when we think it's in the state's best interest. And the state we're actually celebrating 100 years of service, our agency this year. So although we are very small in size, our impact is big. We really look for cases that are gonna have jurisprudential value or that have some important significance to them. One of the cases that I just got served the defense brief on that were representing the state involved a man who was part of a domestic terrorist group, and in April 2020 went out armed in his truck and looking to kill police officers all over, starting in Bowie County. And the Court of Appeals in that case said that it wasn't enough for attempted murder, and the only reason he didn't succeed is because one of the officers fled. And eventually he was surrounded without any incident. But the question before the Court of Criminal Appeals now is whether his acts amounted to more than mere preparation. And so that'll be significant for law and also significant for the officers who were involved in that incident. Generally, how we go about our job is we review all the courts of appeals decisions that are negative to the state and look at the issue and see if it's something worthy of taking up. And if it is, we reach out to the local office that started with the case in the Court of Appeals, and we either take it up ourselves or the local office assists us and takes it up. So even though there's only 3 of us, we do not represent the state in every single case, but we're always there to assist and help them with oral arguments and answer any questions about particular Court of Criminal Appeals practice. We're also involved in lots of other interesting things on the side that our name doesn't even go on. For example, I worked on Mr. Young's case for quite a while, behind the scenes on that one. And so we're available to local counties on a basis to give out advice as well. Right now, I want to say we have about 27% of the PDRs, which are petitions for discretionary review, pending before the Court of Criminal Appeals. That means the case, they don't have to hear it. You're asking them to hear it, and it's really an art to make them want to take your case on and how you present it to them. And so between the 3 of us, we have about over 55 years experience, and we're carrying a very large case. I'm available for a resource for you if you have any questions. I'm happy to take them.
Stacy, thank you so much. Members, do we have any questions? Thank you so much for your time. Chair calls Brian Collier.
Afternoon, Chairman Moody and members. I'm Brian Collier. I'm the Executive Director of the Texas Department of Criminal Justice. I have a very brief presentation for you to cover kind of the overview of the Texas Department of Criminal Justice, and I'll just walk you real quickly through those slides.
Thank you, Brian.
TDCJ, or Texas Department of Criminal Justice, we have 3 responsibilities. One is to operate the adult prison system in Texas, but also to operate parole supervision in Texas. And then we provide funding and oversight, excuse me, for adult probation in Texas. Even though probation is run at a judicial level, their funding and oversight comes through TDCJ. If you look at slide 3, I'll talk about our prisons first. We have 98 prisons in Texas right now with a population of about 125,000 inmates. To give you some perspective, before COVID, we were at about 142,000 inmates in the system. At the end of COVID, kind of the bottom, when population had declined the most, it was at 116. So 116,000 was the low point after COVID. We've seen our population continue to increase as courts re-engage post-COVID. We were actually gaining at about 1,000 a month earlier this fall. If you look down at the bottom of that slide, you'll see a little piece about the number 1 challenge within TDCJ, and that's been our correctional officer staffing. We have had significant challenges with staffing our units with correctional officers around the state. Thanks to you, you actually approved an interim measure for us in April of this past year to give a 15% pay increase for our officers. Prior to that, we had reached an all-time high of 8,000 vacancies. Since that time, we have actually gained staffing every month, and right now we're at about 6,500 officers. We're still not well or at a spot that I would say is good by any means, but we're continuing to make good progress. And in the introduced bills in the House and the Senate, there was an additional 5% and 5% increase, two 5% increases for correctional staff as well. So that will help us significantly. If you look at slide 4, it just gives you a little overview of the on-hand population. Some of the demographics, 92% of our population are males, 8% females. A couple of notes that aren't in there, over 20,000 of the inmates that we have in our system are over 55 years old. Now, personally, I don't think that's old, but nonetheless, because people in prison typically have a medical age that exceeds their chronologic age, a 55-year-old in prison may actually medically look like a 65-year-old. So we track that age point forward, and that's right at about 20,000. Also on our mental health numbers, we have seen significant increases in the number of mentally ill inmates in the system. And we currently have about 32,000 inmates in the system that are diagnosed with mental illness. But let me give you a perspective on that. If you go back to 2017, when we had 142,000 inmates in the system, we were at just under 28,000 mentally ill inmates. So even with a lower population, we have a higher concentration of those inmates with mental illness. The next slide shows you a little bit more on our population profile. 64% of our prison inmates are actually serving time for a violent offense. The average education level for someone in prison, we have their IQ listed, but it's actually 7th grade, 3rd month, based on our educational achievement scores. If you'll go with me to the next slide, I'm going to talk about probation, then parole, and then I'll do interstate compact real quick. In Texas, there are 122 local probation departments that we provide funding, oversight, and training to. They actually report into their judicial districts, but they supervise 206,000 people on probation in Texas. There are 141,000 felons and 64,000 misdemeanors, and we have about 2,500 probation officers in the state of Texas right now. Your next slide talks a little bit about parole supervision. TDCJ, we provide parole supervision for those that are released on either parole or mandatory supervision by the parole board. The parole board is a separate entity. They don't report to TDCJ, but we actually perform the parole supervision for them, for those that are released. We have 67 parole officers around the state of Texas, and we supervise just about 77,000 people on parole supervision. We have about 1,200 parole officers right now. The last slide will show you about Interstate Compact, Interstate Commission for Adult Supervision, for Adult Offender Supervision. You're wondering what the heck is that? In a simple way, this is an agreement among states that also has rules where you can transfer supervision of someone on probation or parole to another state and have that individual actually supervised in another state. Sometimes that happens when you have individuals from another state who actually come to another state, actually get arrested, convicted of a crime, but their home state is in another location. This is a method in which you can have that individual transfer back and be supervised in their home state versus being in the state where maybe the crime was committed. Just to give you a perspective, in Texas, we have about 7,000 people that we actually supervise that are from other states, and we have about 10,000 people from Texas who are actually being supervised in other states. But the interstate, this commission is essentially how that agreement that the states have that helps us work those processes through. Chairman, with that, I'm certainly ready for any questions you may have.
Yeah, thank you for sharing those numbers. Actually, that was the one question I was going to ask. Members, any questions for Brian? Yep, Representative Bojan.
Yes, who pays for the 10,000 parolees or on probation in other states?
The receiving state, the supervising state actually handles the cost of it. It's not cost that comes from your state. It doesn't follow. So that sometimes even fee may be different. So some inmates may be paying fees under supervision, but it's actually the supervising state covers the cost of supervision.
Which is the other states, not our state?
Correct, yes, sir.
And then we pay for it when they come from other states?
Yes, sir. So we're paying for the 7,000, and then other states are splitting up the 10.
Thank you.
Yes, sir.
Thanks. Members, any other questions for Brian? Brian, thank you so much.
Yes, sir.
Appreciate your time.
Thank you, sir.
Chair calls Allen Place.
Good afternoon, Chairman Moody, Vice Chairman Cook, Chairman Leach, good to see you back on your committee. I am here today on behalf of Texas Criminal Defense Lawyers Association. I've represented them since 1999 in this building. In terms of who you'll be seeing on TCDLA this session, David Gonzalez, who is a practicing lawyer here in Austin, will be here on occasion to testify on bills. I will be here on occasion. And Shea Place Taylor is the other person that will occasionally be testifying on these bills as well. Just a little background on myself. I've been a practicing lawyer since 1979. I've been a judge in 3 different courts. I've been a prosecutor and defense counsel. And Chairman Darby, that just means we've been around a long time. That's really all that really means, you know. So TCDLA is about 4,000 lawyers almost from all over Texas.
Oh, you forgot the most important part of your
I did.
political background.
I may not have. I don't know. Maybe. I have had Chairman Moody's seat on a prior occasion, but that seems like a really long time ago.
Well, we like talking to people that have house background. So
I understand. That's the only background I do have. I agree. So there's about 4,000 lawyers that we represent. In terms of the purpose of the association, we exist to educate and support our lawyers and to protect the individual rights given by the U.S. and Texas Constitution. Pretty simple mission in terms of that. Our primary focus day to day on bills that are filed in front of this committee is to focus on actually the process of trial. And I'll not bore you all with the ins and outs of why or what's going on or why this is important today, but basically the process, the due process that a person has when they're faced with a felony or a misdemeanor trial. We are going to focus on that. There are some other issues that may come around, but in terms of what I've told some of y'all already in your office, what y'all want to make against the law or not against the law, I have convinced this group that that's pretty much y'all's call. We're not going to take up that kind of a situation, and y'all may wonder why, but candidly, we think that is y'all's prerogative to decide what is going to be against the law and what is not going to be against the law. In terms of the process that will put somebody in a trial at some point where they could be fighting for their life, or even on a Class B where they're looking at more or less probably a fine, or a Class C for sure a fine, that's going to be, we're going to look at all of those equally. Obviously, felony cases are more serious, but the process of how that trial is going to be is what we're primarily going to focus on. We do want to serve each of y'all in terms of, as a resource in terms of what bills actually mean. I've read a whole lot of bills in my life, and sometimes I still read them and go, I'm not really sure what we're doing here or what it means. Sometimes it's led counsel, sometimes it's just interpretation, but sometimes it's just hard to know. And even though I've been doing this for, like I said, a really long time, sometimes it's hard to figure out what it's doing. And then one of the things that I learned a long time ago on this committee is there are unintended consequences almost every bill that will come out of this committee. While we think we're going to do this, or whether the bill is very narrow and it's only going to do this, we're often just wrong about that. And honestly, we're wrong about it because we don't know how it's going to play back into the system. And the judge that spoke earlier about bail, that's a good example. Bail is a local function in Texas and has always been. And what is a judge in, for example, San Angelo going to do? May be a lot similar to what they may do in Gainesville, but it may be different in El Paso and it may be different in Austin. And so it is a function. And one of the challenges on any bail system is it is pretty much funded by the counties as opposed to the state. So you have the state making some regulations, but bail in and of itself and how it's set is a local function, decisions made by individuals that run for office and are elected in these local communities. So with that, we will be more than glad at any time to come by and do our best to tell you what a bill says, what it does, if we like it, don't like it. That's not as important as being able to tell y'all what we think that it does and what the effect, may be. So I believe that's all I have, unless y'all have any particular questions.
Alan, thank you so much. Members, any questions? If you've been asked to file a bill too, it's also good to ask maybe before you file it what it does. And they'll help you understand that. Be surprised.
We'll give that a shot.
Encounter those situations too. Thank you, Alan.
Thank you all very much.
As a former prosecutor, I want to make sure I follow the rules and give the state the last word in our hearing today. Chair calls Shannon Edmonds, Texas District and County Attorney Association.
Thank you, Mr. Chairman and members. My name is Shannon Edmonds with the Texas District and County Attorneys Association, or TDCAA. Happy Mardi Gras. I'll try to make this quick. I hope you have something better to get to. TDCAA is the statewide association of district attorneys and county attorneys. Those are your local prosecutors back in all of your districts who handle misdemeanor and felony cases in all the courts except for municipal city courts. We have about 335 elected county attorneys, district attorneys, and criminal district attorneys. They employ roughly 3,000 assistant prosecutors, plus hundreds of investigators, victims counselors, paralegals, and other support staff. We enjoy a very diverse membership across all demographic and geographic spectrum. And rather than try to herd all of those cats and get them to agree to take positions on the bills that are going to come before the legislature, you will not hear me or our executive director, Rob Keppel, testifying for or against bills. We're going to be here as a resource to you in the important work that you're going to do. Prosecutors will come before you this session, many of them, and sometimes they may not agree, as you'll see what we get to deal with in our big tent. But we strive on trying to encourage you when you're trying to determine the impact that a potential bill will have, a potential law, that you hear from the prosecutors and just like the defense lawyers who are in the trenches putting these laws into effect every day, and so that you know how it's going to affect your district. Because what you will find as you start peeling away the layers of this onion is that sometimes it seems more like we have 254 criminal justice systems than one criminal justice system. And that's a balance that you have to reach on how to allow communities to administer public safety and criminal justice in the ways that they think are most responsive to their community's needs, while also trying to pass one-size-fits-all solutions. It's a very difficult challenge, and we're here to try to help you do that. You will hear from many prosecutors from all over the state who will come here. In addition, I'm going to be here just to tell you a little bit about myself if we haven't had the pleasure of meeting. I was a prosecutor in Travis County for 7 years. Then I worked for a governor. Then I worked for a lieutenant governor. So I got 2 of the 3. Because I never got to work in the House, I've got to spend a great deal of time the last 20 or so years in this room working with and for the House. And our membership makes me available as a resource. So between our executive director and myself, we have more than 50 years of experience working with the legislature. There are very few issues that are a first impression in front of this group. And so please feel free to take advantage of that institutional memory and knowledge that we have so we can help you make informed decisions, because you will have a lot of decisions to make in this committee. Many bills come in front of it. And we're fortunate to have a chair with a great deal of subject matter knowledge and other members who have been on this committee, but I know many of you are new to criminal jurisprudence. That is generally the rule, not the exception. So don't be shy about asking questions, and don't be shy about asking hard questions until you get a solid answer. And you are always welcome to contact me in committee or afterwards anytime you have a question about legislation that is brought before you. And with that, I'm happy to yield to any questions.
Shannon. Thank you very much. Members, do we have any questions? They're going to save their hard questions for another day. Appreciate that. Thank you so much. Members, that is going to conclude today's agenda unless anybody have a comment. And actually, Shannon touched on it. There's a few of us have been on this journey for a bit. Elizabeth talked about it in her testimony. For those of you who haven't, maybe some of you didn't expect to be on it, welcome to that journey. It's an important one. Is there any further business for the committee to address? If not, Chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned